City of Commonwealth, Massachusetts. Court is open. Please be seated.
Welcome to the Massachusetts Appeals Court on this very wet Thursday, July 10th, 2025. I'm Justice Joseph Ditkoff. To my left is Justice Marguerite Grant. You will notice that Justice Catherine Han is on the computer. She literally can't get here because there's a flood between here and where she lives. So we'll have to keep going. We've also had to change the order a little because some of our attorneys have the same problem. But we will roll with things as well as we are able to. In the Massachusetts Appeals Court, we have a clock here. It'll say 15, and we'll count down from that. When there's 90 seconds left, it'll turn yellow, and when time runs out, it's going to turn red, and it's going to start counting up. That's not how much time you have left. That's how much time you're over. If it does turn red, please finish your sentence, but don't say anything else unless you're answering questions from one of the judges, in which case, please do finish your answer. There's no rebuttal in the Massachusetts Appeals Court. We have read the briefs. We've looked through the record, and so it's best to get right to your argument. Timekeepers, okay? Okay. All right, so with all that having been said, I'll call the first case, Commonwealth versus Baker, number 24P60. I just want to remind the attorneys that we're not going to name the victim either by first or last name or the victim's brother. We're going to use descriptive phrases, complainant, victim, brother, for those. Counselor, whenever you're ready.
Good morning. Sean, may it please the court, Sean Gallagher on behalf of the appellant, Sean Baker. I'd like to concentrate on the indecent assault and battery conviction and the denial of the defendant's required finding motion. The core facts are not in dispute. The Commonwealth and the defense agree that Mr. Baker, taking the facts in the light most favorable to the Commonwealth, slapped an 11-year-old girl on the buttocks, said, "Cute butt," and that was it. Now, in addition to other elements of the crime, it also must be shown, and I'd like to read this verbatim so that I don't make a mistake with it. Quote, A definition adopted by this court provides an indecent assault and battery is essentially an act or series of acts which are fundamentally offensive to contemporary moral standard. It is behavior which the common sense of society would regard as immodest, immoral, and improper. I'd submit on these facts it doesn't rise to that level. In researching this appeal, I focused on indecent assault and batteries that concerned only the buttocks, not a buttocks and other private areas, just a buttocks. And there are very few cases in this Commonwealth that do that alone, because that's what the facts are in those cases. In every single one of those other cases that I found, all of which I cite in the memorandum, the bodily contact with the buttocks was much different, much more sexually suggestive, and also it included comments that were indicative of sexual desire. For example,
why isn't cute butt indicative of some kind of sexual desire?
I don't think it quite rises to that. It's a statement, improper, wrong, inappropriate, but I'd suggest it's not a segue or prelude to an attempted act that is sexual. It's kind of a one-off short comment.
Counselor, wasn't it literally a prelude? Because after that, he pulls down her pants and looks at her vagina?
That is not at all clear from the record. It was a birthday party in the afternoon that went hours, and there's nothing in the record that states the time between the slapping of the buttocks and what happened later in that day. The birthday party lasted for hours. It's not known whether it was half an hour, more than that. So I think one didn't follow on the heels of the other. At least it hasn't been proven that one did. So I think they're separate and they should be treated as separate, Your Honor. Especially given the sequence of these events. So the first one is a slap on the buttocks, and the other one is seemingly more serious. So the one that happened second, I don't think can inform the thinking on what happened first. And to get back to a couple of my points, in all these cases involving an indecent A&B on a buttocks, the time involved was appreciably more than here. For example, and in the physical contact, a grab or squeeze of the complainant's buttocks by the defendant lasting up to 15 seconds. And it's a grab or a squeeze. It's not a fleeting tap. It's a grab or a squeeze for 15 seconds.
Counsel, what if it had been a breast instead of a buttock, and it was the same amount of time? Would that be a different story?
Well, if it was a slap on a breast, it very well could be a different story. And I think there are degrees of intimacy with respect to body parts. And I'd submit a buttocks is probably the least intimate of those, if you go from breast and genitals. And in everyday events where it's not an indecent A&B, but there's a lot of slapping of buttocks in sporting events and things like that, and the intent's not there, and I recognize that, but it's different. It's a little bit different in severity when you're talking about a rear end as opposed to genitals or breasts.
When you say the intent's not there, what intent is the Commonwealth required to prove for indecent assault and battery?
I was putting that in the context of like a sporting event and a slap. There's no sexual intent on that. They don't have to prove an intent. They have to prove the facts that constitute the elements of the crime. And what happens that's in the mix with that is sexual overtures in connection with the physical act. Another case, it's the case in UMass, there's a dormitory, and there's a woman there, and she can't see out the window. She wants to see a dorm. The man in the dorm grabs her by the buttocks, pulls her over, and after that, he propositions her for sex, which she rebukes him, and after that, leading her out, he has his arm under her breast, very close to those. So they're simply different on facts, and I think they're materially different. And they have other cases where buttocks are being drawn to the man's genitals, and there's contact which is repetitive and takes quite a while. One of the things I did in this is I think there's limited case law on this, and I think if this court were to say that this was an indecent assault and battery, this would be the most expansive view of what constitutes an indecent assault and battery to date in appellate cases in Massachusetts.
But why isn't it for the jury to decide what's offensive within contemporary standards?
That's where it starts, but there have been cases, indecent A and Bs, that there have been required findings of not guilty. So it starts there, but it can't be so amorphous that simply because they return a verdict, it's acceptable. So there has to be some constraint, I'd suggest to the court. Another thing.
How do you distinguish Mello?
Mello, sure. In Mello, this involved a woman who worked at a donut shop. There was a patron there. He was regular. There was nothing. he was a patron, she worked there was nothing between the two of them. He got there, and she's outside, and he said to her, give me a hug, give me a kiss. Definitely sexual in nature, the kiss especially. And then he said it again, give me a hug, give me a kiss. No. Then he reaches around and grabs her buttocks, and she forcibly repels him. So I'd submit these are meaningful distinctions. They might seem maybe to a layperson that they're not that meaningful, but in looking at this law on this, I think what might be considered small distinctions actually, as a matter of law, are very important. And I think in my reply brief, I talked about Mello and that it was overtly sexual, the conversation was such that way, and you would know what this guy wanted to do with respect to her body. She repelled him physically. That didn't happen in this case. And again, it's a fine.
So should we write a case saying that in an indecent assault and battery, the victim is required to fight back?
No. But it was mentioned in that court in deciding how they did it, how they came to the conclusion that it was indecent assault and battery. That fact was in their opinion as a basis or one of the bases of how they got to that point. It might have been peripheral, but it was in the opinion. I searched other jurisdictions, and what I found in some, and I cite them, I think in the reply brief, is they find the facts there constitute indecent A and B, but they go on to say this wasn't like it was. May I have one moment?
Sure.
So here, they find an indecent A and B, entire hand-holding for 2 seconds, entire handling, is more significant than a pinch or a slap on the buttocks, which may have been more consistent with a prank or simple harassment. So they draw that line. They find an indecent A and B, but it gives food for thought. Well, where do you draw that line? And I cite 3, I believe, and there's one, 13-year-old made rude sexual comments, slapped juvenile's buttocks, legally insufficient. And that they're different states, they're not controlling. If they're persuasive, they're persuasive. And another point that this is the Commonwealth brought up. And the Commonwealth, in their memorandum, talks about the law has to be such that a reasonably intelligent person, would know what's prohibited by the law. So you're at a birthday party, a person slaps an 11-year-old on the buttocks, says cute butt. If a person is given those facts, would the person say, yeah, I know I committed the crime of indecent assault and battery? The person might say, I slapped her, but indecent assault and battery, it doesn't make that. The other thing is, when I talked about...
Can I ask you a question about the out-of-state cases? I noticed that Jabari is under New York law, where there's an element we don't have of having to be for the purpose of gratifying sexual desire. Do you know anything about the Pennsylvania statute being applied in the 2 Pennsylvania cases? I didn't.
I'm sorry. I don't know if it's identical to ours or has an additional element. If I could send a letter.
I can look it up. I hadn't.
I'm sorry that I don't. The other thing I'd like to point out, when you talk about moral decency and things like that, the Commonwealth didn't address that in their brief. The Commonwealth didn't write down, this act, we know, is fundamentally offensive, it's improper, it's immoral. Commonwealth didn't address it. So I think that's telling in its absence.
Let me give you a hypothetical. Let's say there's a toddler who's visiting her grandmother, and the grandmother reaches over and pats the toddler on the butt and says, cute butt. A jury might find that that's not fundamentally offensive because it's a grandmother and the kid's a lot younger. Why isn't it a question for the jury to decide if this is fundamentally offensive when it's an 11-year-old wearing shorts at her father's house at a party, and the defendant is doing this in front of other people, possibly to see if she's going to protest so that he can do more later.
I started to focus on the end. I understand with the grandmother, and that's grandmotherly.
Question, sorry.
And, so I understand the difference. The point is whether it should be, I'd say it can't be wholly left to the jury, because then it can get really amorphous. You can have, this was district court, you can have 6 people in Worcester and 6 people in Suffolk on identical facts coming to different conclusions. I submit to the court, there has to be some constraint.
But that's not the defining characteristic for a sufficiency argument, is it? I mean, you can have sufficient evidence. Everybody can agree it's sufficient, and juries can come out in 2 different directions. That can't be the defining test.
I agree with that, Your Honor. But my concern is that there's no line. It goes to the jury comes back and says he's guilty, and there's absolutely no line as to where decency ends and indecency begins. And as I said before, courts have come back, appellate courts have come back in this state and said that the required finding on indecent assault and battery was wrongfully denied. So it's not as if every conviction for indecent assault and battery always withstands scrutiny within the context of a required finding of not guilty. I'd submit it falls within the judicial purview to look at whether or not that jury's thinking is too far outside what would be considered, morally offensive or not morally offensive.
All right. Well, I think
My time is up. Is there nothing else?
well, looks like we're done. Thank you very much, Counselor.
Thank you.
We'll hear from the Commonwealth now. Whenever you're ready.
Good morning. May it please the court. Donna Marie Heron, Assistant District Attorney representing the Commonwealth. There was more than sufficient evidence here to sustain the defendant's conviction for indecent assault and battery. And I'm going to look at the entire factual scenario, as we do, in light most favorable to the Commonwealth. Here we have an 11-year-old and we have a 40-something-year-old man that's friends, I think church friends with her stepmother, who she said she met on a few occasions but didn't really know. She's watching a game with her father, him, and the defendant on the couch. Her father gets up to the kitchen to get something. She goes to stand up.
Counselor, do we know exactly how old he is? Did the jury know?
Well, we know he was an adult. I thought somewhere an adult, I'll say an adult. I thought somewhere in the transcript, but I don't have the site
It might be. I was hoping you could tell me where.
I'm sorry, Your Honor. I thought somewhere it was, and I could go back, but I'll just say an adult male. There was no question about that. Friends with the stepmother from church, who smacks the buttocks of an 11-year-old and says, "Cute butt." And the case law has consistently defined a private area as, among other things, as buttocks, and says an unjustified touching of a private area constitutes an indecent assault and battery. And the Colin case, the Quinn case, I've cited a few of them, and that is what we have here, an unjustified touching of the buttocks. And I asked this court to look at the Mosby case, where there was sufficient evidence to sustain the defendant's conviction when he just placed his hand, and this was an adult victim, on the victim's butt and made sexual overtones. I suggest saying to an 11-year-old who you don't really know, "Cute butt," and smacking their butt is an indecent assault and battery, offends moral senses, and is more than sufficient evidence to sustain a decent assault and battery. I also suggest you can consider the entire situation where, although we don't know exactly, she then claims she testified she got up and went outside and played a game of tag. So while I don't have specific time period, we know within this party, she then runs to her bedroom, he follows her in there and pulls down her pants and underwear and looks at her vagina. And it's only because when he starts to lift her hand, I believe was her testimony, that she jumped up and ran into the bathroom and locked the door and was scared. I think considering all that, there is more than sufficient evidence for this jury to convict the defendant of indecent assault and battery, particularly where, as this courts have consistently defined a private area as a buttocks. If there's no further questions, the Commonwealth rests on its brief.
All right. Thank
Thank
you,
you.
Counselor. Thank you both. We'll take it under advisement. Before we go on to the next case, I want to welcome all the interns we have here watching. It's one of the great advantages of having a July sitting. I've actually sat every July. I've been on the bench. Our intention is to come and meet with the interns after the arguments. Because we don't know exactly when all the attorneys will get there, we'll have to see when that happens. But I hope the interns will stay afterwards. Next case is Commonwealth versus Baptista, number 23P 1373. Whenever you're ready, Counselor.
Good morning, Your Honors. Thomas Schack for Mr. Baptista. I'm accompanied today by my law partner, Nancy Schack. And I would like to jump right into this case relative to the fact that Mr. Baptista is the only person who was stopped as a result, and I know you've read the facts, but he's the only person who was stopped as a result of this shooting that occurred over in the Annunciation Road, Wentworth University area of Boston, not too far from the Boston Police Department. There was a shooting that occurred. There was no information the police had other than understanding that some police had heard gunshots, and there was no, they had done nothing more than start moving towards the shooting scene where they believed the incident had occurred. As police arrived on the scene, Mr. Baptista is seen running around a corner. He's got bare feet, or I should say he's shoeless, not barefoot. He's shoeless, running from the area of where the shooting allegedly occurred. And he ultimately, upon seeing police officers who are right in front of him as he makes the corner, he changes directions, runs across the street, and in the process of doing so, he also sheds his overcoat. It's a little bit of I think the court could take judicial notice that it's a time of year that it's a little bit cooler. And almost immediately, he is chased by Boston police officers who get out of that particular cruiser and run after him. Once he becomes aware of the fact that they are police officers, he gives up, so to speak, from running away and stops, and he is immediately tackled to the ground. He's handcuffed, dragged over to a small fence area on the other side of the sidewalk, and is maintained in custody for the remainder of the investigation, certainly that day. And
sorry to interrupt you, Attorney Schack. At what point do you say that your client was seized?
I believe he was seized when he was, as I think the police officers described it, escorted to the ground, Judge.
Okay.
So I would say that the seizure happened at that point. And then, now, drawing your attention to the fact that there were other individuals seen, as the police described it, walking quickly away from the same environment, I would suggest that is a distinction without a difference. And the fact of the matter is one person's running as another person's fast walking. I'm not going to, try to climb into the police officers' minds, but I would say that, but that particular fact is not relevant.
What do we do with the motion judge's findings that no one else was running and your client did not start running as a result of seeing the officers? Are those clearly erroneous?
Well, yeah, I would say that I would absolutely suggest to you respectfully, Judge, that it is erroneous. And the reason is because just because they see him, just because he's running and he's a young black male in Boston, so, I mean, I would respectfully suggest not a shocker that he might be running when others may not. And I don't know what their racial identity is. I don't know what other kinds of, issues they could have. I'm just saying that from an erroneous standpoint, yes, he was running. He was not running away from police officers. He was running away from a shooting scene.
How can we decide that those findings of the motion judge were clearly erroneous when she saw the surveillance video, exhibits 5A and 5B, and we haven't seen it?
Well, Judge, I would say in this situation, it is clear from the findings of fact that the one thing that is certainly clear is that Mr. Baptista in those videos does not have a gun in his hand or no perceptible. There's nothing.
How can we decide that?
Well, what I'm saying is that I'm simply suggesting to you, Your Honor, that based upon I don't think you can necessarily decide that per se, but I do think that the court got it wrong. And I think that the fact of the matter is that even as it relates to the motion to suppress itself, the fact of the matter is that this isn't. I mean, the being stopped while running and black in Boston isn't. It's not just as though there's one case on the subject. There are multiple cases on the subject. At least two on-point issues relative to how the court is supposed to treat the analysis relative to a young black male in Boston running away from or seemingly being evasive or seemingly trying to get away from police. In this case, that would still be seen potentially as evasive behavior. That when he does see the police, he changes directions and goes off in another direction. Again, not a surprise. But I would suggest to you, Your Honor, that in this circumstance, with nobody else being stopped, not another individual, even the people that were walking quickly or fast, according to the Commonwealth.
What's your record cite for the proposition that nobody else was stopped?
Oh, no, Your Honor, I apologize for what I'd like to make clear is that there was a lot of interaction between the police and other folks relative to that. What I'm saying to you is that none of those folks that were stopped were identified. There were witnesses that came up to the police and said, we saw something happen. There was one woman who sees, and in particular it's important to Mr. Baptista's situation, she sees somebody throw something into a bush.
But do we know from this record whether maybe some other police officer might have stopped some other suspect on the other side of the parking lot?
Well, we don't have any testimony to suggest it.
So, because it's this defendant who's filed the motion to suppress, are you saying the Commonwealth should have introduced evidence as to every other person?
Oh, no, Judge.
And whether or not they were stopped?
What I'm saying is that's a significant weakness in the decision, and that the fact of the matter is that if you saw, I mean, I've seen the video. I know this court's not going to see it. The jury certainly saw it. They made their findings and determinations relative to what they saw certainly, but again, that connection.
Counselor, I didn't see where any of the officers described the walkers as walking fast. Did I miss it?
Well, I would say that there were a number of different types of descriptions. There were people that were walking, and again, my apologies if the language is slightly different and it could be interpreted differently. I'm using that to describe what a variety of police officers had indicated relative to their investigation that day. There were other people who were interviewed by police officers who actually were in the area, but nobody has been identified on the record relative to whether or not they also saw what was going on, whether they were stopped relative to this. So there's one thing that we do know. One person was stopped, and that was Mr. Baptista, a young black male. And now, as it relates to the issue of shedding your coat, running out of your shoes or running in socked feet or shoeless, feet, changing directions when you see police officers, I would suggest that are all inherently reasonable behavior under the circumstances. If somebody's running away, and it's just as equally, possible that they're innocent as it is that they're guilty, and if we're applying that standard as we should here in Massachusetts, then the
Wouldn't equally likely be reasonable suspicion?
I do think that no, I don't think that necessarily it would be reasonable suspicion. I think that if you take the concomitants of everything that happened that day, Justice Ditkoff, I think that if you took the concomitants of what the police officer's testimony was in the light most favorable to the Commonwealth, you certainly would have had, you certainly could have had reasonable suspicion to stop him. But to stop, and as I was discussing with Justice Hand, but to stop and then to seize him, and simply because he's a person who's moving away at a fast pace, my word, not theirs, at a quicker pace or a rapid pace, and perhaps even comparatively to others who are coming from that area. What we obviously don't know is, the physical conditioning, who these other individuals were, what was, but my point is that was presented as as an issue of consciousness of guilt. I mean, it really, and particularly at the trial, it just, that type of issue just does not bode under the case law here in Massachusetts, and particularly under cases like, Warren and other, I wouldn't describe them as progeny necessarily, but other cases. And I would suggest to you that respectfully that just because he's running away, it does not give him the ability to tackle him, handcuff him, and then start questioning him while being handcuffed behind his back and dragged across to a fence area, when, clearly nobody else was.
I have a couple questions for you. What exactly is the evidence that you're saying should have been suppressed? It looks to me as though the trial counsel conceded at the motion to suppress hearing that he was not seeking to suppress the gun or the sneakers. I'm not sure about the coat. What exactly is it you're saying should have been suppressed?
Everything that came after the arrest, Your Honor. What happened while he was in custody at Boston Police Department, the gunshot residue test that was taken of his hands, which I intend to get to, but those all of his statements, the fact that he refused to speak to police officers at the scene.
Did the motion to suppress seek to suppress the statements?
I do not believe it sought to. No, it did not. It did not seek to suppress the statements that were from the custodial statements from the police department. I'm sorry, Judge.
It's okay.
No. So my response is that in this situation, Mr. Baptista is also ultimately convicted of constructive possession as opposed to actual possession.
Why constructive? I thought this was tried as an actual possession case.
Well, no, he wasn't. There is no actual. There's no tangential evidence tying him other than the GSR residue test to any of the three.
So are you saying that if the evidence of actual possession is circumstantial, it's not actual possession, it's constructive possession?
No, I'm saying that there wasn't enough. There was not enough evidence presented. Other than the linchpin in this case was the GSR test. That was plain and simple. There was nothing else tying him to a weapon, that weapon, or any of the other two weapons. One of which was discovered. One was discovered on the roof of a community center locally, and also another one that was not discovered that day. So there were the ballistics identified 3 different firearms as having been used in the shooting. Mr. Baptista does not argue that this was that bush was along the route that he had run. It's just that there's nothing, no fingerprints, no DNA, nothing tying him other than the GSR test. And we know, Your Honors, that's not specific to the weapon.
In closing, the assistant DA said that the jury should look carefully at the surveillance video, and he encouraged them that it depicted the defendant losing his right sneaker right near the bush where the gun was later found. And we don't have the surveillance video. Are you, and as I understand it, you haven't argued that that closing was inaccurate. So doesn't that tie him to the gun?
Well, no, Judge. Certainly the argument doesn't tie him to the gun. But regardless of whether, I mean, the Commonwealth's entitled to argue their case. As a former prosecutor, I know that. And while that might have been an issue, and one that we certainly, it's not something we did not recognize. We recognized it, but not from the standpoint that it was nefarious in that context. Here we have, I don't care whether he said, there's a video showing Mr. Baptista holding a gun and firing in the air and running away from the scene. That's not the evidence that the jury saw, and I believe that trial counsel closed that door, relatively reasonably. So unless there are further questions, Your Honors, I would rest on our brief, and I would also respectfully suggest to you that this is simply a running in Boston while black case. Thank you.
All right. Thank you, Counselor. We'll hear from the Commonwealth now.
Thank you very much. May it please the Court, Kenneth Steinfeld for the Commonwealth. There are 5 points I'd like to discuss that came up during my brother's argument. First, he said that once the defendant became aware they were police officers, he stopped. That is not supported by the record. In fact, that's contrary to what the judge found. He did not stop when he saw that they were officers. He kept running. Secondly, turning to Justice Hand's point about when the seizure occurred, my brother just said that it occurred when he was wrestled to the ground, but I have to say as an officer of the court that it actually occurred prior to that. The Commonwealth conceded at the argument on the motion to suppress that it occurred when the officers got out of the car and yelled, "Stop," citing Warren. So it actually occurred before my brother says it occurred. I don't think it matters because all of the key events had occurred by that time, but just as a proper statement of when the stop or seizure occurred, it was before he was wrestled to the ground.
I'm sorry, exactly when?
Well, it is when they began. It's not clear how long after they got out of the car they yelled, "Stop."
Right, so the yelling stop definitely seizes, but I couldn't figure out when that was from the suppression transcript.
Well, both officers said that they thought that the other officer had said it,
Yeah.
but they weren't sure when. I would point out in the the last event that occurred that's relevant was the discarding of the sweater. And so in her findings, the judge's findings, she says that that occurs prior to the chase when she's listing the events. If you look at page 20 of my brief, it says it's clear the defendant was running away from Annunciation Road. As the defendant was running, he discarded his coat in the middle of the street. So, and then it goes on later to talk about the chase. So it really doesn't matter when the chase began or when the stop occurred because they hadn't yelled stop yet or started the chase as far as we know at that point. But even if they said...
So, just to be clear, your viewpoint is that the seizure was after the discarding of the coat?
Yes.
Okay.
But it doesn't have to have been. But even if one could read the findings and the record from the suppression hearing as saying that he discarded the coat after they started the chase and yelled stop, I don't think it does, but it could be interpreted that way, then it's not included in the analysis because the stop has already occurred. But he shed his shoes, so just a coat is sort of an added layer on top of that. But yes, I'm saying that he discarded the coat and the shoes before the stop occurred. But as I said, the stop occurred well before they stopped him across the street. My brother also said that they tackled him, also not supported by the record. As to Justice Ditkoff's point about the speed of the pedestrians, there's no evidence that any of them moved fast at all. And the finding of the judge, which was supported by the record, was that no one else was running. Some of them were walking, they were all started off in the direction away from Annunciation Road, and when the defendant burst from the group and ran towards the police, they kept walking a little. Some of them stopped and looked back over their shoulders, but there's absolutely no evidence that any of them moved fast at all. They were curious about what was going on behind. So the fact my brother keeps saying that he was the only one they stopped, he was the only one who was running from the scene. There's, as I said in my brief, there was a control group of what people on the sidewalk at that time and place from the shooting who had nothing to do with it would have done. So the fact that all those people are there, and he's the only one running, that provides a very sound basis for the police to stop him. And I say that because at the suppression hearing, the trial prosecutor said, and I think this is the key of the case, we're talking about seconds, we're talking about feet. This case does not involve a half a mile, a quarter mile, 15 minutes later, and half an hour later. This is seconds. The officers themselves, both the 2 officers who stopped the defendant and the 4 officers who were on the other side of Annunciation Road, heard the shots and they were responding immediately within seconds. And the person who ran at them at full tilt, without shoes, without a sweater or a coat, his timing was perfect for him to have been the shooter, based on everything that the officers themselves had heard. So it makes sense for them to stop him. If they had not stopped him, they would have been derelict in their duties. This is not a case of a black man walking through Boston being stopped. All of those cases involve descriptions where officers know that there is a black male with a certain kind of clothing who stopped in some other neighborhood. Here, there's nothing like that. There's no description of the shooter. They saw a man run at them, then change speed and turn up. So I would say that there's no racial element of this case at all. And further, as I point out in the brief, that was never raised below. The defendant didn't argue it, didn't say it. The first we're hearing about this, that being a factor in this case, is on appeal. So I don't think the court should take that into account. Sorry, as to Justice Grant's point about what is being suppressed, I think it's clear that the only evidence that was inculpatory, that was used at trial, that might have been, was the gunshot test of his hands. So I think that's really the focus of the issue. He didn't move to suppress his statements at all. And there's nothing else. There's no evidence at trial that he didn't talk to police at the scene.
But you'd agree the gunshot residue was pretty important evidence?
Absolutely. Oh, yeah. I think there's still a case, but as to sufficiency, it was admitted, so of course we take into account, we don't take into account whether or not it was admitted properly. And I would add, as to the GSR, which I didn't point out in my brief, which perhaps I should have, that the expert testified that you only need 3 particles of GSR for it to be a positive. Here, the defendant had 5 particles on one hand and 9 on the other. So 3 times as many as one, and 1 2/3 time on the other. And though I admit there's no expert testimony that says the more particles one finds, the more likely it is that that hand shot the gun, I think that's a reasonable conclusion that the jury might have reached. And just the fact of the gunshot residue at all is very, very incriminating.
But you'd agree that if we reversed said the GSR should have been suppressed, we'd have to have a new trial. It wouldn't be harmless.
No, I don't think that it would be harmless beyond a reasonable doubt. I'm sorry, I'll say that again. I think that it would have been harmless beyond a reasonable doubt. But I might lose that argument if I'm allowed to say that. I certainly would make that argument. It was very, very important to the Commonwealth's case, but you had a lot of other factors besides that. You have the temporality. You have Dr. Ojikutu, who saw the defendant throw something into a bush immediately afterwards that Officer Walsh found in that bush that was in the immediate flight path. So there's plenty that ties the defendant to the shooting other than the GSR on his hand, but I'm not going to say the GSR was not very, very important evidence. I'd also like to talk about the defendant's statement to police, which was highly incriminating. I've rarely seen a statement that is as incoherent, all over the map, inconsistent, and obviously false in a lot of meaningful ways. And if you look at it, you have to turn it up very loud because he speaks very slowly, so I found that helpful. If you watch all 5 of the videos that I've submitted, which were admitted, he's a person who's clearly in control of all of his faculties. He knows what he's doing. He knows why he's there. He knows what's going on. There's no sort of, there's no question that he has borderline intellectual functioning or that he's under the influence of anything. And he says things like, I don't know whether I was 10 feet away from the shooting or 100 feet away because I'm not a scientist. And that sort of statement just has to make you wonder, okay, what is this person doing? Why would a person say that who had nothing to do with the shooting? And his explanation of what he was doing in that area was absolutely nonsensical. One does not go from Jamaica Plain to Brighton on the Orange Line by getting off at Roxbury Crossing and walking up Parker Street, as the officers showed by their testimony and by the maps that were admitted. So he had no explanation for his being in the neighborhood. And his repeated statements about whether or not he was on Annunciation Road, as I said, he said to the officers, I probably was on
Wouldn't you want to switch to a bus in Roxbury to get to Brighton?
Pardon me?
Wouldn't you want to switch to a bus in Roxbury if you were going to Brighton from?
That I don't know, but the officer said, who knew the area intimately, said that if you're on the Orange Line and to get to the Green Line, you would go to Ruggles.
Oh, for sure.
Not to Roxbury
Oh,
Crossing.
Ruggles.
So that's all.
Yeah,
I have no
probably.
intimate knowledge of that. I'm going straight from the record. It's not a way that if you're on the Orange Line, that's not the fastest way. It is the fastest way, however, to get to Annunciation Road. If one's destination were that area and one were on the Green Line, one would get up at the stop where the defendant says he got off. And so I think that statement helps a lot and also adds to the GSR, which I don't think there's any way to get around that. But I don't think that the judge erred when she didn't suppress and found that there was reasonable suspicion, nor do I think the evidence was insufficient as to his actual possession of the gun. This was an actual possession case. The Commonwealth claimed, and of course there were various other charges, including ABDW, of which he was found not guilty, that he was shooting the gun. So there's no claim by the Commonwealth that he constructively possessed it, and the state did not argue that he had knowledge of and the ability to exercise dominion and control over it.
I have more of a comment than a question about your brief. It's very helpful that you so conscientiously listened to the recording of the defendant's interview and gave us some quotes from what he said, and that you transmitted the interview, the 5 clips, to us. It would have been even more helpful if in your brief, particularly when you quoted, if you gave us a minute and second cite to the parts of it. As we're getting more and more video evidence before us, that would be helpful. I know the rule doesn't require it.
No, I always do. That was a time issue in this case for filing the case. I was way behind. I always cite both the counter on the timer itself plus any timestamp. So that is my practice, and I apologize for that. And I realized while I was going through it, that's why I had to listen to it. And I actually wrote down some times of where things were said because I didn't put them in the brief, but I absolutely do that. And
Could you provide those times to us? If you've written down some times, we'd love to have them.
I don't have them with me.
You'd submit them.
In a letter.
Oh, yes, absolutely. I'd be happy to.
And anything that you quoted in your brief at pages 16 to 17, just give us the timestamps for those quotes.
Absolutely. I'll tell you which of the 5 videos and what the timestamp is on the video for each of those. I apologize for not having done that in the first case.
Great.
One last comment I'd like to make. I cite the case of Commonwealth versus Vick when talking about a fact circumstances in which a defendant runs from police. I also cite the case of Diaz from this court. Vick does involve that circumstance, a defendant who's walking away from police when he sees them, but the discussion in that case is about his flight from the scene. So I just want to make that clear, that site is not a perfect site. It does have that fact circumstance, but the argument in that case has to do with flight from the scene, not from an officer. Diaz, however, is exactly on point and says it has a guy just like here who...
Is that the recent Diaz? There's a recent Diaz that's got
I think it's fairly recent. I think it's like 100, Mass App 101, something like that.
No. There's a recent SJC Diaz.
No. This is an appeals court Diaz case that talks exactly on point about a guy who sees officers. I'm sorry, he's running, he sees the officers, and then he keeps running. So if the members of the panel have no further questions, I'll be happy to rest on my brief.
All right, thank you, Counselor. Thank you all. So nice to see a family law firm. And we'll take the case under advisement. And then we'll take the break. He's getting full. They're outside. We're going to do that, and then take the break, and then start that. Some of our lawyers are outside, and they'll be in a second. I did warn you, Counselor.
Good morning.
Let's everyone get set up before we start. All right, looks like everyone's ready. This case is adoption of child number 24P1274. No, I don't need to remind you, but this is an impounded case. We'll use words like child, mother, father, and let's use uncle. Let's not name the uncle. Just call him uncle.
Thank you, and I think in my brief I refer to him as brother, but...
Or brother. Well, yeah, brother's fine too. Just let's not use his first name.
Yes, thank you. May it please the Court, Roberta Driscoll-Weiss on behalf of the appellant mother. At issue in this case is whether
Hold on, I'm sorry. We're going to split 7.5, 7.5.
We are not, actually, Your Honor. I apologize. We're splitting 10 and 5. I'm going to take 10, and my brother's going to take 5.
Oh, okay. 10 and 5. All right. So 10. Thanks.
All set? Thank you. At issue in this case is whether the evidence at trial clearly and convincingly supported the trial judge's decision to terminate mother's parental rights. I suggest that it did not, and accordingly, I ask this Court to vacate the judgment and remand the matter for further proceedings consistent with that decision. Whether mother was fit or unfit at the time of trial is really not what I'm arguing today. I think the judge probably could have found mother unfit at the time of trial. The question is whether she had the evidence to terminate mother's parental rights. In deciding to terminate a parent's rights, the trial judge needs clear and convincing evidence that mother's unfitness is going to continue into the future to a near certitude. And I think that evidence was lacking in this case. This is, sometimes when preparing for these cases, you try to think of a sort of a catchy phrase to, make the case memorable. And I think this is a tale of two mothers, really. There's the mother that my client was prior to September 2022. And then there's the mother that my client was after September 2022. In September 2022, my client sought and received inpatient psychiatric services, and for the first time in her life was prescribed appropriate medication to deal with her mood disorder. She was prescribed trileptal, which is a mood stabilizer, and from September 2022 through the end of trial, which was something like 22 months later, there was no evidence of any of the chaos that the judge repeatedly refers to throughout her findings. This is a situation where I think the judge who, I have a great deal of respect for this trial judge, but I think she missed the forest for the trees. She mentions that mother received psychiatric treatment. She mentions that mother is receiving, was prescribed Celexa and Trileptal, but she failed to recognize the vast difference in mother's behavior and capabilities once that Trileptal was added to mother's medication regimen.
Can you explain in some detail, beyond just the fact that there wasn't another violent incident described in the record, what else reflects the effect of Trileptal on the mother's ability to parent?
Well, there was mother's testimony itself. So at transcript pages 326 through roughly page 329, mother's trial counsel elicited from mother that as a result of being prescribed this Trileptal, I think mother's exact testimony was that her mental health was way different, that she was calm, that she felt completely different after the addition of this much-needed medication to the regimen. And what's unfortunate is that mother, or I guess depending on how you look at it, mother wasn't faced with many situations in which to demonstrate this change in temperament. The one that is mentioned in the record is a visit at a trampoline park where there was some sort of miscommunication about a permission slip or something to that effect. And the old mother might have reacted quite drastically to this challenging situation, but she didn't. She was able to keep her cool. She was able to resolve the situation, and she was able to have a successful visit. And in addition to that, she sat through many days of trial where many rather unpleasant things were said about her, and again, maintained her composure, did not fly off the handle. And I think what's missing here is that element that mother's unfitness was likely to continue into the future, when I think it was pretty apparent by the time of trial that there had already been a pretty significant change in mother's demeanor. And unfortunately, all of the services that mother complied with, she underwent a neuropsych evaluation, she completed a parenting class, she completed domestic violence training. All of those things occurred prior to the addition of the Trileptal to her medication regimen. So I suggest that this case is really unfortunate from mother's perspective, because she was not diagnosed properly earlier, and that it took, as long as it did for that to happen. But as I said, it was something like 22 months before the trial was over, and there was no indication of these behaviors that the trial court relied on. And every conclusion of law that this judge issued in her findings relates to events that occurred prior to September of 2022. So she goes into great detail about a January 2022 incident where mother and father, got into an argument, and mother admittedly was entirely inappropriate by, destroying the kitchen. But again, that was 8 months before she was hospitalized and properly medicated. And so the question is there any evidence that mother is likely to engage in that kind of behavior again? And I suggest to you the answer is no. And so I think where the trial judge erred here was in this sort of lumping together all of mother's services into sort of one bucket, and not realizing or recognizing that this had been...
So what about her refusing the parenting program a year after she started the medication, and completing the intimate partners violence program but not taking accountability? That's also after.
I believe that the intimate partner violence program was prior to September of 2022, but the parent aide actually testified at trial and testified to mother's engagement in the service, and her attendance at visits with mother, and how mother was asking for her to explain some of the child's developmental...
So finding 171, in August 2023, mother completed the IPV program. Is that not right?
I apologize. That there was another program that occurred in 2020 also. So okay. I apologize. I didn't...
But you're not saying that's wrong?
I'm sorry?
You're not saying that finding's wrong? or
I'm saying
maybe
it
don't
doesn't
know.
tell you the whole story
Yeah.
of this
Oh, sure,
mom.
I wasn't suggesting it today. I just,
But I think, even if there was a misstep, is that enough to terminate a mother's parental rights? I suggest to you that it isn't. And I think the better course of action here would have been for the trial judge to decide, even if she decided that mother was unfit at the time of trial, to utilize the review and redetermination process in the juvenile court and give mom that 6 months to see, is she holding it together? Can we talk to the psychiatrist about, what's the likelihood of continued benefit of trileptal? Can we put in additional services now that mother is in a frame of mind to be able to properly absorb that information and make good use of it? So I think to hold it against her that she didn't benefit as much from services that were provided to her when she wasn't capable of benefiting from them, I think really does a disservice to mother. So as I said, I really think this is a tale of two moms. I think if you look at her behavior prior to September 2022 and you look at her behavior after 2022, it's very different. And this court in Linus found that a 4-year delay between a parent's, or a 4-year distance in time between a parent's issues with their mental health and the termination of parental rights was too long to use as those events as prognostic. This is 22 months. Is 22 months too long? I believe that it is.
What about the lack of stable housing?
Well, so it's interesting because at trial, the judge very clearly said to the parties, oh, housing is, that's not a reason to find a parent unfit, but yet she goes on to note in her findings that mother lacked stable housing. I will point out that mother had stable housing until the child was removed. And very often, the thing that gets you stable housing as a indigent individual in Massachusetts is having custody of a child. Once the child was removed, mother lost her housing. There's nothing to suggest she wouldn't qualify for housing again. She was not evicted for cause. She was evicted because she no longer qualified for that type of housing without having custody of her child. So I think to suggest that she would never again be able to obtain housing is pure speculation, and there was nothing in the record to suggest that that was actually true. And again, I suggest that the opposite is true. The trial judge even noted during the trial that lack of housing was not a basis for unfitness.
all right.
If I could just take one
Sure.
more second and just sort of say that, I think if the court looks at Linus together with care and protection of Bruce, where the mother and Bruce similarly had significant mental health issues, but was able to still properly parent the child, mental health problems in and of themselves are not a basis for a finding of unfitness. And I suggest that mother's mental health issues in this case had been ameliorated, and it was error for the trial judge not to recognize that.
Right.
Thank you.
Thank you, Counselor. Hear from counsel for the father.
Yes, good morning. If it pleases the court, my name is Mark DeJoy, and I represent a 37-year-old mentally handicapped father, which was undisputed at trial. Father testified that he had oftentimes had trouble confusing thoughts, and that those thoughts he had to calm himself to understand what was being told to him. Social worker at the date of the removal said to the father at the time of the removal that his mental handicap would not allow him to parent the child. Father had done many things on the service plan. The service plan was a moving target in my estimation, Your Honor. There was, within a period of 18 months, there were 4 service plans. And the service plan, Your Honor, read like almost every other service plan, Your Honor, excuse me, every other service plan that we have. There was nothing particular about the service plan as tied into this father. Alona says that the department needs to find services that are tailored to the mental handicap father.
And so he gets a parenting program that's specially designed for persons with cognitive disabilities, and the social worker testified about trying to use language that's easy to understand, frequently reviewing things, had ADA meetings. I mean, where's the misstep?
Well, you want to, I never saw the social worker provide a service, or certainly didn't follow the disability policy of sending this information up to the ADA coordinator pursuant to the DOJ HHS case. That the services, when you look at the services, if I might, the social worker, if this is from the January 7th action plan, the social worker would like father to understand the child's unique needs in development. Well, that's an admirable goal. I don't know how a father who doesn't read understands what the social worker is looking for, but I don't see a tailored service plan that says, if you do A or fail at A, I'll be able to determine whether you can meet that requirement that I'm looking for you to do or not. So in the case of May, the unpublished opinion, the court there said that mom had given DCF ADA request, and at that time, DCF provide those services, and at the end of the day, the mother couldn't meet the goal, so the child was adopted. I do think, Your Honor, that the time frame, the father at the beginning is critical when these services need to get in place, because at some point in time, as it happened in this case, when he doesn't see progress, he in this particular case, the fact specific, he moves to New York. He did do services, Your Honor, the one you just mentioned. He also tried to improve his reading with JRI. He took a parent evaluation with Dr. Brisson. I think the only, not the only, but social worker relied on this app that would read all these documents to him. But nowhere in the record does it say that at some point in time, DCF took their time to explain what they needed from
He testified, the social worker testified, he would use language that was easy to understand, and he frequently reviewed things with the father. Why isn't that evidence?
Well, I think what we're reviewing, reviewing the service plan. Here's what I want you to do. The service, so how you're going to get there is what my complaint is. That the service plan was very detailed. It said what you want to do, but it was a to-do list. It wasn't, here's how you're going to prove this to me. That's why I don't think they met the reasonable standards, because they said everything, but that looked like everybody else's service plan that I've seen.
So, Counselor, you said in your brief that 42 U.S.C. 671 requires DCF to make an ICPC request when a parent moves to another state. It's a pretty long statute, and I didn't see where it says that. Could you tell me what part of the statute you were referring to?
I am not sure if I can point it out this time, Your Honor. I will need to go look at it and revise with a letter, if I may.
I'm sorry, I didn't catch that.
Would I be able to revise with a letter, Your Honor? I couldn't point it out.
Yes, absolutely. You could send us a letter within a few days.
I will, Your Honor. Thank you.
All right, can I
Oh,
cut you
that's
off
my
there?
brief, Your Honor. Thank you.
Thank you, Counselor. All right. So it's 10 and 5?
Yes, it is.
Okay.
All right. Good morning. May it please the Court. Department of Children and Families, Lynn Murphy, representing the agency. The trial court properly terminated parental rights in this case, where there were lengthy histories with the department and many other service providers for both parents. Mother had services in place on and off for 15 years. Father had services in place on and off for 10 years. During that time, no significant improvement was ever made by either parent. Now, mother, as we know, had, as I detail in my brief, the same pattern of behavior kept reappearing. There were times during this 15-year period that mother was able, with sufficient services, DCF, DDS, DMH, shelter staff, many people working together, she was able to participate in mental health treatment for herself. She had been seeing a psychiatrist since 2019. She was in therapy. But what would happen was eventually, 2 years, there were 2 times, she seemed to do okay for 2 years with those supports, but then she would become overwhelmed and unable to send the kids to their therapy appointments. The kids were not going to school or to daycare. She stopped attending her therapy and mental health appointments. She, when she lived in the shelter, sometimes her hygiene was good. She was able to keep the room clean. Other times she was not. So this pattern has gone on for such a significant period of time. We had reunified the older siblings of this child with the mother on 3 occasions, and 2 occasions at least. I think one of the children was really removed 3 times, but there were several attempts to reunify mother with the older siblings. It never worked.
What do you say to the mother's argument that the trileptal was a sea change and DCF didn't give her enough of a chance after that?
Are you referring to the mood stabilizers that supposedly were, right? Okay, well, the reason that wasn't not sufficient to convince the court that there was actual change was because, as I said, mother had been involved in psychiatric care since 2019, so 3 years. And yes, she did get the mood stabilizer. And yes, it did appear that the year prior to trial, there were no documented events of mother becoming violent but that wasn't the only problem here. I mean, her volatile behavior was one aspect of the case. The other aspect was her inability to get stable and suitable housing, which was existed for the entire time of the 15-year period, and she was never able to remedy that. Also, mother's poor judgment continued. She continued to be involved with family members who put the children at risk, including her brother. That had not changed. So
I don't get the brother thing. He's a level 1 sex offender, so his risk is low.
No, risk is low I would disagree. I believe
to be a level 1 sex offender, does that mean that the Commonwealth's best experts found by clear and convincing evidence that he poses a low risk and low harm?
Right, but even a low risk for a small, vulnerable child is something the department and the judge found very disturbing. And also the fact that the mother testified and father both testified that it was in essence, there was no big deal, and that he could be left alone with children, and had in fact been left alone with children. That kind of risk, no matter how you want that risk assessed on the spectrum, I think is very disconcerting. And it showed mother had an attachment.
I mean, is that what DCF does? It takes away children from level 1 sex offenders?
Well, actually, the uncle did have an open case, and he did have his children taken away. Now, the record doesn't explain why, but there were definitely problems with that individual as a parent and as a babysitter.
Based on the mother's knowledge of what the brother had done to her sister, would that be an issue whether or not the brother was registered as a sex offender at any given level?
I don't know if the record speaks to exactly what happened with the brother. We know just what you have pointed out, that he was a level 1 sex offender. His own children were removed. I don't know that the record shows exactly what those charges were and what was the outcome of that. But again, the point I think that the court was making and concerned, and the department was concerned too, the poor judgment on the part of mother in this case, which never resolved. In her testimony, you could see this because in fact, she denied that she had violent tendencies.
Was there anything in the action plans that required her to limit access to the uncle? I didn't see that, but I might have missed it.
I don't believe that was a specific action plan task, but that does not mean that the department didn't articulate that concern, and the social worker testified extensively as to what the department expected of mother. She had many issues, and the fact of allowing the uncle access was one of many. There were many other more pressing issues such as her mental health, the housing, and trying to get mother to be able to parent, to alleviate those parental deficits. And again, this is a case where the department worked with numerous providers. We put in everything in place that we could. The social worker, extensive testimony talks about having ADA meetings for both parents, having counsel present to help, having other, the DMH workers contacting other workers that were involved. And the biggest problem was we just never saw a change. And again, mother had a history, and even father, sadly for him, he did comply. He was complying, but then he had just decided, okay, I'm going to abandon all services, and he moved to New York. So at that point, there was nothing further the department or anyone else could do. We didn't even know he had moved. I mean, and I think the social worker testified, finding out where people were living was the biggest problem, one of the biggest problems in the case. We didn't know where mother was unless she was, sometimes she was not, she was either at the grandmother's or shelter, but father in particular, trying to find out who father was involved with, where father was living.
I presume you could do things if someone moved to New York if they were clear about where they were living and their plans. I mean, you could arrange for something with the New York department.
Yeah, there could have been something done, but we didn't know that father had left. He did not disclose his location, and he was very cagey about it. In fact, and again, the social worker's testimony is very helpful in shedding light on this. He said, I believe father is no longer in Massachusetts. So even when the social worker was testifying, at that point, he still had no clue where father was. So there was no way that there could be services in place. And father certainly didn't ask for any. And his new wife testified and said, oh no, father never asked me for help. And basically father abandoned all services, and at that point.
That's really unfortunate. He seemed like he was on the right path before that.
He was actually better at complying with services. He had periods where he would, but he just was never able to gain. He would have as the expert testified, he needs somebody, unlike mother who was able to do a little bit with services in place, but father needed even more support services, and there was expert testimony on that, and father abandoned all services, so at that point there was no further, the trial court felt enough was enough and terminated parental rights. If there are no questions, I will rest on my...
I have one question. Your friend says that the social worker was a specialized social worker for persons with disabilities. I didn't see that in the record. Is that true? Communitas was, but the social worker, the ongoing social worker.
Well, I don't believe the ongoing social worker was particularly, I mean, all social workers are supposed to know about mental health issues, but this particular, however, that's why we have the AD meetings and clinical reviews, and we did have a person who had such expertise in those ADA meetings. And then, like I said, we also have clinical meetings at the area office. So even if I think the social worker was fairly new at the time, the ongoing work.
He testified, it was like his first case.
I believe that is correct. If there are no further questions, I will rest in my brief. Thank you very much.
Thank you, Counselor. And finally, we'll hear from Child's Counsel.
May it please the Court, Your Honors, child supports affirmance. The trial judge correctly found both parents unfit based on current circumstances, and that adoption by the child's pre-adoptive family is in her best interest. The record supports that determination. The arguments raised on appeal, including ADA and kinship issues, were either waived or properly rejected. As counsel for the child under Rule 1.14, my job is to take the position my client would take if she could make a reasoned decision based on all the facts and circumstances. I've reviewed the full record. I've met with the child, her pre-adopted parents, and the adoption social worker. That's how I came to the position I'm presenting today. And I stand here asking the court to affirm. The position I'm taking is based on three key conclusions from the record. Mother's unfitness at trial, apparently admitted, is based on history of violence and instability, including unstable housing, and poor judgment leaving my client in the care of a sex offender, level whatever. 2, the father's unfitness persisted despite concrete accommodations, and his capacity really never rose to the level of safe parenting. And 3rd, the child's pre-adoptive placement legally, developmentally, and emotionally meets her needs and protects her stability. And I'll address those. The trial judge heard 13 days of testimony and issued findings assessing both parents' current capacity to parent. Those findings reflect careful judgment, not just quantity, but credibility, and apply the correct legal standards. My client's now turned 5 years old on July 1. She's lived nearly her entire life with her pre-adoptive family. And they meet her medical and developmental needs. And the judge found that returning her would cause her serious psychological harm. And that finding is supported by the record and consistent with this court's guidance and veto. Cutting to the chase, mother argues the judgment relies on stale evidence, but the judge explicitly credited her recent treatment and still found her unfit. Findings 85 to 93 reflect her long-standing untreated diagnoses, anxiety, depression, panic disorder, which had not changed at the time of trial. And the record is clear on her violent episode just before removal and continued contact with the level 1 sex offender, that's finding 77 and 78, and an altercation before removal resulting in her sister's black eye and assault charges. That's the legal test that matters here, and the judge applied the correct standard under Alona. Father argued that DCF failed to accommodate his disability, but no ADA motion or claim was made below. As Willow confirms, that issue is waived. And even if reached, the record shows multiple accommodations, referrals to Communitas, Catholic Charities, DDS, and a one-to-one aid. That's finding 120.
So, Counsel, you said in your brief that the social worker was specialized in this, but I didn't see that. Where would I find that if you stand by that assertion?
I'd have to find, I can't remember. I would need to find that.
Because the cites here are the parts of the record that are higher numbers than the record goes to.
Then I have to check, Your Honor. I will check that and get back to you. I had a different version of the record I was originally working with, and so...
That would explain a lot.
I tried to clean it up, and I hope I got it all, but I will look.
All right. It's fairly important, so if you do find some support for that, please send us,
Certainly.
16L letter in the next few days.
Absolutely.
I'll let you finish up if you want. Last sentence.
The child is deeply bonded with her pre-adoptive family, and again, she's grounded. She plays with her dog in the living room of her home now, and it's not a placeholder placement. And that's not speculation. That's in the court's findings, 242 to 243. And so under veto, that finding is entitled to deference.
All right.
Thank you, Your Honor.
Thank you, Counselor. Thank you, all of you. These are always difficult cases, and I really appreciate the help. It's a huge record, and so it's really appreciated. What we're going to do now is we're going to take a break, no more than 15 minutes, and when we come back, Judge Shin will be here, and I'll be off, and so we can get to the first criminal case that I'm recused on, and then after that, I'll come back on, and we'll do the other adoption case and then the railroad case. So we'll stand in recess for 15 minutes.